Chapter 5. Basic terms or definitions. So let's read about what is deposits. Okay, Sir G. According to Section 231 of the Act, the term deposit includes any receipt of money by way of deposit or loan or in any other form by a company, but does not include such categories of amount as may be prescribed in consultation with the Reserve Bank of India. The above definition of deposit is inclusive one. It includes any money received by way of deposit or loan or in any other form. Repayment of deposit is time-bound. It can be secured or unsecured. But there are certain amounts which shall not be considered as deposit 1. The amount received from government 2. Amount received from foreign government 3. Loan from bank 4. Loan from public financial institution 5. Amount received by issue of commercial papers 6. Amount received from another company 7. Amount received as application money 8. Amount received from director of the company 9. Amount raised by issue of secured debentures 10. Amount raised by issue of convertible debentures 11. Amount raised by issue of non-convertible debentures 12. Security deposit from an employee 13. Amount held in trust 14. Amount received in the course of business 15. Amount received as advance for sale of immovable property 16. Amount brought by the promoters 17. Amount accepted by Nitty Company 18. Amount received as should 19. Amount received under collective investment scheme 20. Amount received by a startup company 21. Amount received from alternate investment funds, etc. Now shall read about who is depositor. It states that any member of a private or public company who has deposited money with his company is a depositor. Also, any person, even if not a member of the company, who has deposited money with a public company is also a depositor. Now my question is, from you, what do you think? What is eligible company? Sir, the term eligible company means a public company having a net worth of not less than 100 crore rupees or a turnover of not less than 500 crore rupees and which has obtained the prior consent in general meeting by means of a special resolution and also filed the said resolution with the registrar of companies before making any invitation to the public for acceptance of deposit. Yes, you are right. It states that any company can accept deposit from its member by following the provisions specified. First, by passing resolution at general meeting. Second, the company is required to issue a circular to its members, including therein a statement showing the financial position of the company, the credit rating obtained, the total number of depositors, and the amount due towards deposits in respect of any previous deposits accepted by the company, and such other particulars, in the prescribed form and manner. According to Rule 4, the company shall issue such circular to all its members by registered post, or speed post, or by electronic mode, in Form TPT-1. Further, the circular may be published in English language, in an English newspaper, and in vernacular language, in a vernacular newspaper. Sir, what is given in addition with this form? In addition, a certificate of the statutory auditor of the company shall be attached in Form TPT-1, stating that the company has not committed default in the repayment of deposits, or in the payment of interest on such deposits accepted, either before or after the commencement of the act. And what if company defaults? In case a company had committed a default in the repayment of deposits accepted, either before or after the commencement of the act, or in the payment of interest on such deposits, a certificate of the statutory auditor of the company shall be attached in Form TPT-1, stating that the company had made good the default, and a period of 5 years has lapsed since the date of making good the default, as the case may be. Such circular shall be issued on the authority and in the name of Board of Directors of the company. Third, the company is required to file a copy of the circular containing the statement with the registrar within 30 days before the date of issue of the circular. Fourth, the company is required to deposit on or before 30th of April each year at least 20% of the amount of its deposits maturing during the following financial year and kept in a scheduled bank in a separate bank account to be called deposit repayment reserve account, and according to Rule 13, the amount shall not at any time fall below the 20% of deposit maturing during the following year. Fifth, the company needs to certify that it has not committed any default in the repayment of deposits accepted either before or after the commencement of this act, or payment of interest on such deposits. In case a default had occurred, the company made good the default, and a period of 5 years had lapsed since the date of making good the default. Sixth, if the company accepts secured deposit from its members, then the company shall take steps for the creation of charge on the property or assets of the company. It may be noted that in case a company does not secure the deposits, or secures such deposits partially, then the deposits shall be termed as unsecured deposit. Seventh, in case a company fails to repay the deposit, or part thereof, or any interest thereon, the depositor concerned may apply to the tribunal for an order directing the company to pay the sum due, or for any loss or damage incurred by him as a result of such non-payment, and for such other orders as the tribunal may deem fit. Eighth, the deposit repayment reserve account shall not be used by the company for any purpose other than repayment of deposits. Rule 13 also states that the amount so deposited in the account shall not be used by the company for any purpose other than repayment of deposits. Ninth, a company is not permitted to accept deposit which has a redeemable time period of less than 6 months. Further, the maximum time period of acceptance of deposit shall not exceed 36 months. Provided that, for the purpose to meet the short-term requirement, company can accept deposit which has a redeemable time period of less than 6 months, subject to the condition that: first, such deposits shall not exceed 10% of aggregate of total paid-up share capital, free reserves, and security premium reserves of the company. Second, such deposits are repayable only on or after 3 months from the date of such deposits. 10th, a company is permitted to accept or renew any deposit from its members, including other such deposits outstanding, as on the date of acceptance, or renewal maximum up to 35% of the aggregate of its paid-up share capital, free reserves, and securities premium account, provided that a specific IFSC public and private company may accept monies from members not exceeding 100% of aggregate of total paid-up share capital, free reserves, and security premium reserve of the company. In addition, the maximum limit in respect of deposits to be accepted from members shall not apply to following classes of private companies. First, a private company, which is a startup for 5 years from the date of its incorporation. Second, a private company, which fulfills all of the following conditions, namely, 1. Which is not an associate or a subsidiary company of any other company. 2. The borrowings of such a company from banks or financial institutions, or any body corporate, is less than twice of its paid-up share capital, or 50 crore rupees, whichever is less. And 3. Such a company has not defaulted in the repayment of such borrowings, subsisting at the time of accepting deposits. Under this section 11th, no company shall a circular inviting secured deposit unless the company has appointed one or more trustee for creating security for the deposit. Also, a written consent shall be obtained from the trustee for depositors before the statement shall appear in circular in the form of advertisement to the effect that the trustee have given their written consent to the company to be so appointed. 12th, where the depositors so desire, deposit may be accepted in joint name, not exceeding 3, with or without any clause, namely, jointly and survivor, etc. 13, every depositor may nominate any person at any time. The nominee shall be the person to whom his deposits shall vest in the event of death. 14, a company, within a period of 21 days, from the date of receipt of money, or realization of check, or date of renewal, the company is required to furnish a deposit receipt to the depositor, or his agent. The receipt shall be signed by the duly authorized officer, and state the date of deposit, the name and address of the depositor, the amount of deposit, the rate of interest, and the maturity date. 15th, a duly audited return of deposits, in DPT3, containing particulars as on the 31st of March of every year, shall be filed with the Registrar of Companies, along with requisite fee, on or before the 30th of June of that year. 16th, the company has no right to alter any of the term and condition of deposit, or deposit trust deed and deposit insurance contract. 17th, a public company shall disclose in its financial statements, by way of note, about the money received from its directors. In case of a private company, it shall disclose in its financial statements by way of note, about the money received from the directors or the relatives of directors. As a one-time measure, every company other than a government company shall file a one-time return of outstanding receipts of money, or loan by a company not considered as deposits, from 1 Street April, 2014, till the 31st of March, 2019, inform DPT3, with the Registrar of Companies, within 90 days, from 31 March, 2019, along with requisite fee. 18th, in case the company fails to repay deposits, both secured and unsecured, on maturity, after they are claimed, it shall pay penal rate of interest of 18% per annum for the overdue period. 19th, if any company inviting deposits, or any other person, contravenes any of the deposit rules for which no punishment is provided in the Act, the company, and every officer in default shall be punishable as under, with fine, extendable to 5,000 rupees, and, in case the contravention is a continuing one, with a further fine up to 500 rupees, for every day, during which the contravention continue. It states that if a company had accepted any deposit before the commencement of the Companies Act 2013, and such deposits or interest thereon remain unpaid as on such commencement, then the company shall file a statement and from DPT-4 with the registrar. The statement shall contain 1. The particular of deposit accepted by company, 2. Deposit and interest remaining unpaid, and 3. Arrangements made for repayment of deposit. The statement shall be filed within 3 months after the commencement of Companies Act 2013. Also, the company shall repay such deposits within 3 years from the commencement of the Companies Act 2013, or on or before expiry of the period for which the deposit were accepted. Whichever is earlier, a company may make application to the tribunal, seeking extension of time for repayment of deposit accepted before commencement of Companies Act 2013. The tribunal may allow further time for repayment of deposit, as it may deem fit, but before passing the order, tribunal shall consider the financial statements of the company, the amount of deposit and interest payable thereon. Sir, what if company contravenes? If a company fails to repay the deposit or interest thereon, in accordance with the time allowed, including extended time period allowed by tribunal, then the company shall be liable for fine minimum ₹1 crore and maximum up to ₹10 crore, and every officer of the company who is in default shall be liable to imprisonment up to 7 years and fine for ₹25 lakhs, but which may extend to ₹2 crore or both. A company may accept deposits from public only if it is a public company, and whose net worth is 100 crore or more, and turnover of the year is 500 crore or more. The company shall comply with such rules as may be prescribed by central government. In consultation of RBI, the company shall obtain rating with respect to its deposits, and rating shall include net worth, liquidity, and ability of company to repay the deposits. On due date, the rating ensures adequate safety, and shall obtain from recognized stock exchange. Rating given to company shall be informed to public at the time of invitation of deposits. Rating shall be obtained every year during tenure of deposits. The company create a charge on its assets in favor of deposit holders within 30 days, and the value of assets shall not be less than the amount of deposits accepted. The company shall accept only 10% of aggregates of paid-up capital, free reserve, and security premium account as deposits from members. In case company accepting deposits from public other than members, then only 25% of aggregates of paid-up capital, free reserve, and security premium account as deposits, and in case of government company, only 35% of aggregates of paid-up capital, free reserve, and security premium account as deposits. Note: those 10%, 25%, and 35% includes the amount of outstanding deposits, as on the date of acceptance every eligible company shall obtain credit rating at least once in a year, which should be filled with ROC along with return of deposits. Credit rating shall not be below than the minimum investment grade rating. Every eligible company who invite deposits shall issue circular in the form of advertisement in English and vernacular language newspaper having wide circulation in the state in which ROC is situated, and circular shall also placed on the website, if any, of the company. Sir, what if company fails to repay the deposits? If a company fails to repay the deposit, or any interest due thereon within the time specified under Section 73 and 76, then the company shall be punishable with minimum fine of 1 crore, or twice of the amount of deposits accepted by the company, whichever is lower, and maximum fine is 10 crore. Every officer of the company who is in default shall be punishable with minimum fine of 25 lakhs, and maximum fine is 2 crore, and imprisonment up to 7 years. Sir, what about them who willfully contravene such provisions? If it is proved that the officer of company who is in default and contravene such provisions willfully with intention to deceive the company or shareholders, then he shall be liable under Section 447